All right, let's dive right in. Today, we've got a real legal drama for you, a classic showdown between a single homeowner and his entire HOA. And this isn't your typical squabble over, overgrown lawns or the wrong color mailbox. Nope. This is a battle over secret votes, transparency, and the fundamental rules that govern a whole community. So let me ask you something right off the bat. Can your HOA board, the folks making decisions about your home, your money, actually vote on big issues without ever holding a meeting that you can go to? Now, your first reaction is probably, no way, of course they can't. But the case we're about to unpack shows the answer is way more complicated than you'd think. Okay, so let's set the scene. It all starts in April 2020. A homeowner named Norm Burns has a few complaints he brings to his HOA board in Arizona. Then, just a couple of weeks later, on May 3rd, the board takes official action on those complaints. The catch? Mr. Burns claims they did it all behind closed doors. And boom, that one move kicks off a legal battle that lasts for nearly 2 years, ending with a final decision in January of 2022. So, first up, let's really dig into the homeowner side of this. For him, this wasn't really about what the board decided. It was all about how they did it. This was, at its heart, a fight for transparency. The entire foundation of Mr. Burns's case, the whole thing, rested on this one powerful idea, that on that day, May 3rd, 2020, his HOA board broke Arizona's open meeting law. His claim was that the board took action in the absence of an open meeting, basically shutting him and every other homeowner out of the process. So, to really get where he's coming from, we've got to introduce the first major player in this legal showdown. It's a specific Arizona law that deals with planned communities. For our purposes, we'll just call it the law for open meetings. And what's so wild is just how crystal clear this law is. It says all board meetings have to be open to all members, not some of them, all of them. It says members have a right not just to attend, but to speak. And get this, even informal chats among enough board members have to be held in the open. The whole point of this law is to make sure everything happens out in the sunlight. And just in case there was any doubt about what the law was trying to do, the law itself has this killer line. It says that anytime there's a question, you have to interpret the law in favor of open meetings. That's the legal firepower Mr. Burns was working with. Seems like a pretty open and shut case, right? Well, not so fast. Okay, so that's one corner of the ring. Now let's look at the HOA side, because they came to the fight with their own legal champion, a totally different state law. This one applies to all nonprofit corporations in Arizona, which includes most HOAs. Let's call this the law for written consent. See, this law, it opens up a totally different playbook for how a board can get things done. It allows a board to take an official action without a meeting at all. The only requirement is that every single director has to agree to the action in writing. It's a tool that's really designed for speed and efficiency. And this brings us to the absolute heart of the HOA's defense, which was honestly pretty clever. They basically said, hey, how could we have violated the open meeting law if we never actually held a meeting? They argued they didn't hold a secret meeting. They just used a different legal tool to take an action instead of a meeting. And they didn't just pull this out of thin air. They pointed right to their own rulebook, their bylaws, specifically Section 3.5, flat out gave the board the power to take any action in the absence of a meeting by getting that written consent. So not only was this allowed by state law, it was literally baked into their own governing documents. So here we are, a total legal showdown. You've got one law that screams open meetings for everything, and another law that says, you can skip the meeting sometimes. How on earth does a judge make sense of two laws that seem to completely contradict each other? Well, this brings us to the climax, the judge's reasoning. So what the judge did was essentially put these two laws side by side and realized, wait a minute, they're not actually fighting each other. He saw that the open meeting law is very specific. It's all about what has to happen when a meeting is held. But the law for written consent, that provides a legal alternative to holding a meeting in the first place. The key insight is that one law doesn't cancel the other out. They just apply to two different situations. Okay, so the judge's logic here is super important. It basically went like this. Step 1, he said, yup, both of these laws are totally valid. Step 2, he decided they don't actually conflict. Why? Because step 3 and 4, one law sets the rules for meetings, and the other law sets the rules for taking action without a meeting. And so, for his final step, he ruled that both laws can exist at the same time and be followed without causing any legal problems. All right, so after all that legal wrangling, where did the chips fall? What was the final verdict? And maybe more importantly for you, what's the big takeaway from the case of Norm Burns versus his HOA? Well, the verdict was clear and decisive. The judge dismissed Mr. Burns's petition. He ruled that the HOA's action was completely lawful. Why? Because they didn't violate the open meeting law, because they didn't hold a meeting. Simple as that. Instead, they correctly used the other legal path available to them under both state law and their own bylaws. So, let's break down the big lessons here, the stuff you really need to remember. First, and this is crucial, a legal action is not always the same thing as a meeting. Second, your HOA's bylaws matter a lot. You've got to know what they say. Third, general state laws, like those for nonprofits, can give your HOA powers you might not expect. And finally, this whole case just perfectly illustrates that constant tug-of-war in any organization, the need for efficiency versus the need for transparency. And all of this really boils down to one final big question for you to think about when it comes to your own community. When a decision has to be made, what do you value more? The total transparency that comes with holding an open meeting for every single issue, or the efficiency of letting a board act quickly and decisively when they all agree? There's no single right answer, but it's a question every homeowner and every board member really ought to consider.